Welcome back. From the Me Too movement to protests at universities, the naming and shaming of alleged rapists has often posed several legal questions. In many cases, men accused of rape are applying for protection orders under the Protection from Harassment Act. But a High Court ruling has found that publicly naming someone as a rapist does not amount to harassment. Wits Law School Professor Bonita Meyersfeld has written extensively on the issue and joins us now to help us understand how current thinking is changing on the matter. Prof, thank you so much for your time and for joining us this evening. So now, at the inception of the trends of the hashtag #MeToo movement, what do you make of victims and survivors of gender-based violence naming their perpetrators publicly? What factors do you believe led to this shift in thinking?
There's always been a silencing around gender-based violence, a sense of society somehow shaming the victim, really, rather than the perpetrator. And we know this, it's an old story. Often to engage in the legal system, to go and report any kind of gender-based violence to the police is more traumatic, often for survivors, than the event itself, but certainly more traumatic than trying to just deal with the aftermath of this type of horror. And so if you take South Africa, we have less than 8% of all reported rapes are prosecuted to conclusion, and that's without thinking about appeals. So there really is no, there really are no constraints around there's around prosecutions. There are really no remedies available in reality for women who experience gender-based violence. And in the absence of those safety nets, in the absence of being able to own one's truth, to be able to speak publicly, women are trying to find a way of speaking their truth. Speaking their truth means having an audience that is, speaking the truth means having an audience that will believe you and hear you. And the formal structures, police, courts, are not those audiences.
Right. I mean, we are now seeing, the legal challenges that the victims are facing when they name their alleged perpetrators, particularly in relation to defamation cases and protection orders. Has this trend been going on in terms of alleged perpetrators taking their victims and retaliating in this way?
Yes. So what we've seen in South Africa and abroad as well is a slew of legal mechanisms being used to respond to and to further silence women who are speaking out. For example, their defamation claims, right? You bring a claim saying you've defamed me, and those claims can run into millions and millions of rands, dollars, euros, depending on your jurisdiction. What we're finding here is a lot of men turning to the Prevention from Harassment Act, which it's very ironic because it was a piece of legislation that was developed as a suite of acts and legislation to protect women from gender-based violence. So men are going to court to say, look, by naming me as a rapist, or by identifying me as a rapist, or by even intimating that I might be the person, I'm being harassed by this individual. And we're finding that the lower courts are often granting orders, and some of those orders, protection orders, and some of those protection orders are just beyond the pale. We had one instance in which a woman on a private WhatsApp group spoke about the fact that this man had raped her. When Uyuneni was tragically raped and murdered, there was a release of the information on that WhatsApp group that she hadn't been involved in. That information was released. Her abuser took her to court, got a protection order against her, and the protection order said she was never allowed to speak ever again to anyone about any rape that may have happened. She was completely gagged. And only after we went to the High Court to appeal that case did the judges of the High Court confirm that was an abuse of of the legislation. And we're seeing that happen, like a co-option of or a misappropriation of legislation that's been designed to protect women from gender-based violence is now being used to further silence women who come out and talk about gender-based violence. So that's what this article is about and what we're trying to address.
Right, right. So with this ruling, Prof, what does it signify for victims of gender-based violence and the ability to speak out? Does this then allow them to be more frank and more open in naming their perpetrators?
The really important, one of the most important parts of this judgment is that it said two things. One, that by naming a person online or publicly naming a person as having raped you does not in and of itself constitute harassment. There's a very extensive definition of harassment in the Act, but it said that simply by stating it is not harassment, which is a correct legal interpretation. The Act also says harassment is, conduct may constitute harassment, but even if it does constitute harassment, you then need to ask, well, is it unreasonable? And in this instance, the court said, even if it was harassment, it was not unreasonable. And it was not unreasonable because of the context in which we live, a context in which conservatively a third of women in this country are raped. And it's an interesting phenomenon because everybody you speak to agrees that gender-based violence, that rape is so prolific and such a demonic component of our society, and it must stop. At the minute that one individual stands up and says that I've been raped, well, then she must be lying. And it's this disjuncture, this psychological disjuncture between acknowledging a terrible reality, but refusing to acknowledge the individual when they come and speak out. So the Act has insisted, this decision has insisted that courts look at the Act within the context of gender-based violence. And it's certainly not saying that it will never be harassment, but these are the factors that have to be proved. And the most important part of this Act is to say, look, wake up. This is not a complaint in a vacuum. This is not one person, even though it is one person speaking. This is a complaint in the context of what's a low-level civil war. The court doesn't use that language. But it really is in the context of something that is much bigger than any one judgment, and we need to consider that.
We most certainly do. Prof, unfortunately, we have run out of time. Really would have wanted to extend this in terms of also the attitude of the judiciary in granting these protection orders against the victims. But thank you so much for your time and unpacking this for us. That was Professor Bonita Meyersfeld from the Wits Law School speaking to us there about the latest on that protection of the protection orders that have been granted to perpetrators.